ના જીએસટી વાળો નહીં અધર મેનલી ગ્રાઉન્ડ છે અને ખેતી કામ માટે પણ he was absconded for 1 year એફિડેવિટ માં થાય છે એનું એફિડેવિટ સોઢાભાઈ ઓફિસી કે એમ મહેતાભાઈ એટલે આપણે ખાલી કોપી કરવું આગળના 4-5 ઝેરોક્સ કરીશું હરેશભાઈ દાનાભાઈ શું આવ્યું
only Kiran Patel wali matter હતી ને which Mr. Shah was asked to verify what he wants to deposit. But he said some council has come to argue.
council you are arguing
only on the law points. I don't want to de-argue the matter.
આપવાની હતી સાહેબ આપને તો પછી સાહેબ નું આંદોલન હતો તો હું સાહેબ ને સર્વિસ કરવા માટે પ્રયત્ન
Only give me a few minutes.
no issues. I have all the time. But
To be very fair,
I have already made up my mind. When he argued, I made up my mind and I told him clearly in the open court. They also know, everybody knows what is my view.
years, 43 years of practice, my experience is that till the time the London judge signs the order,
you have all the right.
we are entitled to persuade the court.
Entitled not, I am not on entitlement. You are definitely entitled. I never curtail anybody.
That view
But-
can change condition. If something is found,
Hello, let us
then definitely you can be changed.
somebody. You can change nothing. I am not on that. After his arguing, I said, why not?
I'll tell my lord, with all, for the first time in the entire India, MPIDA came to be introduced in Maharashtra. The first case was of Uday Acharya. I don't know whether my lord has come across that case or not. Unfortunately, throughout I was appealing for him. So I can say the act has been introduced only because of Uday Acharya. Because we had a big fight with Kirit Somaiya. And therefore this act was brought because Kirit Somaiya was in the ruling party. Now everywhere, every state has adopted, I can say it's replica of the Bombay's act, Maharashtra act, except in Jammu Kashmir, the act is replica, but it provides for compounding of the orders, which is missing from all others. So we can say conveniently that it's replica of whatever the MPID court has said, whatever act is. And therefore, when I argued the matter to Apex Court, in the case of Uday Acharya, various law has been settled. And that is what exactly I want to
But I am not saying no for bail.
And I need not trouble my lord.
But I'm only saying you pay something and take bill.
If my lord suggests something,
I have already, that was the reason why the matter was kept. એટલા માટે જ રાખી છે. It
I-
was
I
not
believe-
on law point.
I
The
believe.
only reason was I said that, see, you have received money
Correct.
and it is not a disputed fact that he has not received money.
Correct.
So I said, these are investors' money or depositors' money. Why not deposit in the court? We'll see later on.
The amount, the quantum of amount,
That was what was to be decided today.
I'll tell my lord. If we go by the document, I joined the company as a partner, that was limited liability, holding a share of 2.5%. And that was in the year or August 2021, subject to correction. The amount involved in the present case is about 68 lakhs or so. Subject to correction, it may be rounded off to 54. 54 lakhs. 54 lakhs. So even if the trial begins, let's presume that the trial begins, then also I will be answerable for the amount which has come to me.
That is
Out
what
of
I
that
said.
kitty, out of that kitty. The issue involved in the matter is that if we go by the records, the transaction of the complaint started in the month of July 2021. I entered into the company as a partner only in August 2021. So the transactions were ongoing. Before that, whatever amount I have received, there is a finding of the civil court that I was an employee of the company. Now, if I was an employee of the company and during the course of my employment, I have received my salary, then my lord, whether that salary will be counted in the present case, my lord, look it from any angle, it will not. But still, my lord, to show our bona fides, of course, we have to show our bona fides. My lord will suggest some reasonable.
I have left it to your side,
My lord,
but
maybe,
then, and also to the other side. Like how much money should be deposited so that he can't-
may I suggest, maybe around 10% of the. My lord, I'm told, subject to correction, I'm told that the main culprits,
they'll come, they'll also.
no, they have been arrested.
They'll also come for bail.
That's right.
So,
So
see,
those who are the
I-
actual
today-
beneficiaries
as of today, what I feel is tax is made only because,
for recovery,
not for
it's
recovery
a
also,
sort of
but
recovery.
to, safeguard the deposit. Mainly, so that some money can come back.
Correct. This is the only act where the provision has been made for attachment, etc., etc. Competent authority can be appointed, etc. Though there are so many legal issues involved in the matter, but still,
But right
My-
now we are on bail, so that's why
My
I
therefore-
told him, પહેલા જ મેં કીધું હતું ને કે I'm ready to grant bail, but subject to something.
that એટલે તો મેં my Gujarati may not be that good. My lord will pardon me on that. I had taken instructions. The moment the person goes behind the bar, my lord will appreciate the only wife is available in the
Yeah,
house.
so we can make some arrangements also, no, that they પહેલા કરે છે કે something
Sir,
right,
we'll
something just
immediately-
now,
we'll
something after
immediately
4 months,
deposit.
something after 6 months.
My lord, we'll immediately divide 5 lakhs. Don't indicate your company. Before release from the jail, we'll divide 5 lakhs.
I think,
And thereafter some reasonable amount.
I have no doubt, you take whether they are agreeable or.
On the face of it, when my
Face of
learned
my
statement
judgment
says
indicates that
10%, it looks ridiculous.
I-
10%
I
looks
was-
ridiculous.
Today we have kept it only for this. That we can come to conclusion that how much, and then usually I don't allow the depositors to withdraw the money. I keep it there till the time the whole case is.
To be invested as per the procedure, to be invested. So like the wife, I have taken instructions from her. There are no children. It's only husband and wife.
They'll have to run around or something.
Correct.
Something has to be done. They did enjoy with the money. So now today they have to.
I must
For,
say one thing.
for
I
7
must
to
say-
8 years, they did enjoy with that.
Let me take it lightly. I earn 100 rupees. I give it to my wife. Wife never knows by what means I have earned it. I think this is a practical approach.
No, I'm not on the
So
right.
therefore, even if we look at the wife's angle, she may not be even aware of in what business
What
my
property do
husband
you
is.
have? Must be having problem. It is,
I'm told out of 54, 30 has been refunded back to the company. To the company.
This is the company પાછા એમાં જમા કરી.
that is a matter of trial, I'm not.
ના, એનું સાહેબ, એનું police will take.
I know, let it come on record that right now I'm only thinking about this. I said we will give it back to you. And somebody else will give it.
Well, I think it's a reasonable.
Today we are not calculating anything. Today we are saying that how much out of the 54 are you ready to deposit in the court?
But
So that we go out.
initially-
And then we'll give you time also.
Initially, I'll divide 5 lakhs. I don't want to make a commitment which will fail.
You have.
Forget about,
And I must take
forget
it-
about
I
commitment,
must make
he has to
myself clear.
declare on the record. Then only court will impose conditions accordingly, making some concession.
No, I'm making
One
a
more
statement
thing,
across the-
one more thing, Karthik. That, does he have property also? He has property.
Maybe some residential.
I have told you, investigating officer.
Still under
Apply
investigation.
10% change and property.
आपने.
કારણ કે એ હોય સાહેબ, તો પછી તો ગવર્મેન્ટ ને જ કે ને કે આને attach કરવું.
એટલા માટે જ કહું છું કે you have investigated.
Sir, otherwise also.
It's still under investigation.
આઈઓને મેં કીધું હતું આપને ખબર પાડો કેટલી પ્રોપર્ટી છે.
આજે તો એમના માટે રાખ્યું છે, છતાં એને હું કહી દઉં, પૂછી લઉં કે
So that we can bring out on the property. So that everything that will come zeroes down to what actually I have to pass an order. And you take instruction 5 lakhs is 2 lakhs. So take instructions that how much you deposit just now after 6 months, how much?
Why is it, even I have trouble and appeal before this court on pro bono basis. Nothing beyond that.
That's why I won't doubt.
won't be relevant for disposing bail.
No, I'm showing the financial position.
Everybody, whoever comes under
May I
DPID has the
suggest-
same
may
position.
I suggest- Well, deposit 5 lakhs immediately before you. Another 5 lakhs within 3 months.
3 months I am planning to deposit a bit. We are planning to order a bit more. Within 6 months, but whatever. So, let.
I believe my landlord had some suggestion.
પેલા છે ને કંપનીનું 21,000 ની સેલરી જે છે ને એ આમાં ગણાય. પાર્ટની
But that's the difficulty.
એમાં સેલરી લખેલું છે એકાઉન્ટ.
And
Exactly.
salary account લખેલું છે, there is a finding of civil court. Finding of facts will always remain binding on this court.
અને એકાઉન્ટ મારી પાસે આવી ભાઈ એમાં છે.
You make, increase this first initial deposit. થોડું વધારે, and then we'll see, and then we'll get the property. Details and all that, what we have, right? And then we keep it on Monday.
My lord may suggest the fee. That's how I'll call it.
That is like disclosing what will be the final order. Court can give a
And
hint.
of course, if we are, but we
I'll-
are dealing fairly with the court.
No, I was thinking of depositing 50% of the amount. Now, go in the bill side.
Still I take instructions, but it's not.
It's ever. And the rest of the money, you can say that 6 months, 8 months, whatever, or
But others are there to recover.
I know, but I have got to recover a lot of money.
I must
Others will
be
also
fair to
come
the-
this way only.
They come.
It is not-
I recently, it was a 3 crore matter in which we recovered about how much, 1.5 crores? Yes. 1.5 crores we had to recover by only on that stage. But that was.
And it depends on the
Maybe I
person
was-
to person, the
Yeah,
whole
no, no, but
activity. to
that
the
also I
person.
was fooled. The court was taken for a ride. So now I'm very cautious. એટલા માટે. That matter, the court was taken on as Swami Vadi.
Yes.
There was nothing
And now everybody is running away.
running away.
And we have prepared a chart of it, if I'm not permits.
Okay, I'll take it.
51 lakhs was the salary received by us. Out of that, 32 lakh, 3 lakh 25,000 was the investment made by us with the company. So in fact, we also fall in the line of the victims.
And this complainant money, how much you had introduced this complainant?
Nobody. Therefore, I wanted you to see, look at a few points, and then I'll leave it to the court. My lord will just give me 10 minutes to show how the matter has proceeded with. And then And possibly my legal arguments may have hurdles also. My lords of the FIR. Please look at the road. My lord may turn to running page of the FIR. The statement. And that mentions about Mr. A, that is Chandrakant Bhai Patel. I'm not that. My lord has got page 2, running page 2 of the statement. Yes. My lord, the paragraph beginning from જેની વિગત નીચે મુજબ છે. My lord, Chaubat. Yes. Then my lord may turn to about third line. From that, my lord will find immediately thereafter the name of one Chandrakant Bhai Patel. My lord, Chaubat. The complainant comes across one Mr. Chandrakant Bhai Patel, who was already having a project. He goes to his project, satisfies himself. May I read it, sir? Yes. અને ફર્ધરની ફાર્મિંગની માણસો વગેરે જવાબદારી એલએલપી પોતે સંભાળે છે. તે વાત કરતા હું આ ચંદ્રકાંતભાઈ પટેલના પ્રોજેક્ટ જોવા ગયેલો અને મને તે પ્રોજેક્ટ સારો લાગતા ચંદ્રકાંત પટેલને મને AS એક્વા એલએલપીના પાર્ટનર હિરેન પટેલ મોબાઈલ નંબર સો એન્ડ સો આપેલ હતા. बाद में Rajkot आवेली my company. So he has given his number of the present applicant. My lord, Chaubat. There one name appears. Then my lord may turn to the next page, or rather on the same page. Matter remain on the same page. And same paragraph. Where it says, પાર્ટનર હિરેન પટેલ મોબાઈલ આપેલ હતા. મેં રાજકોટ આવી મારી કંપનીના ડિરેક્ટરો સાથે પ્રોજેક્ટ બાબતે વાત કરેલી જેથી તેઓ જણાવેલા કે જો પ્રોજેક્ટ પ્રોફિટ સારું હોય તો રોકાણ કરવામાં કોઈ પ્રોબ્લેમ નથી. તેમ કહેતા અમે આ હિરેન પટેલને ફોન ઉપર પ્રોજેક્ટ બાબતે વાત કરતા તેઓ અમને તેમની એલએલપીના મેનેજર સાક્ષી પટેલ તથા અવિનાશ સાંગલે ના નંબર આપેલા અને લોકોને 2-3 દિવસમાં રાજકોટ મોકલાવું છું. ત્યાં આવીને
Hiren Patel is the present accused. Hiren Patel is the
That's
present.
right. That's the end of the matter.
Why did they contact Hiren Patel?
Mr. Chandrakant told them that he is a person you can contact him. This is the mobile number. They telephone him. He says that I will contact over these two managers. And these managers will send some team to you and explain the project. That's the end of the matter.
And at that time, what were you doing?
I was working as an employee. Admittedly, I was working as an employee. After that, I have no contact of whatsoever
Employee in the
nature.
meeting? Employee in the meeting
Employee
as
a manager.
what does the act say regarding that? Who all are liable?
But that time, the other 14 persons were liable.
Who all can be brought in as accused?
Section 3.
Section. That even if you are in employment and if you are beneficiary of something, you are equally liable. Good well, just go to the act for it.
No, but when he introduced them to the company, how much did the company?
I have not introduced them to company.
You have given the phone numbers to them.
No,
That you are the manager.
Mr. Chandrakant gives my number that if you want to invest, you can contact me. When they contacted me on phone, I said better you contact these two people who are the managers of the
So
company.
what is in the FIR?
That's all. Not even a single word here and there. Two lines, that's the end of the matter about this. I can understand that I have persuaded them to make the payment. My lord will not find even a single word against me. Apart from this. And on the relevant date, I believe that the records will show that there were 14 partners of the firm, of this LLP firm. I'll withdraw myself even if a single allegation is found beyond that. And therefore, neither I have come in contact with any investor, nor I had any occasion to meet them, nor I had any occasion to persuade them or receive any amount from them. And if I have received the salary, my lord, like me, there are so many who has received the salary. And then my lord will find the concluding part, as it normally happens, which are the wordings of the prosecution. While concluding, they name everybody and these are the persons involved. Nothing beyond that. It's a general state. All the agreements have come on record. I'm nowhere concerned with that. And before I became the partner, the transaction had started.
You become the partner.
And that was the end of August 2020. 21. August 21.
Payments are made in 22.
It started in July 21.
Payment, making payment.
Yes. Payments, the company started receiving payment in July 2021. Please turn to running page 6 of the FIR, where my lord will find the details.
On page 4 you can read.
That's it. I read.
पेज 4 देख सकते हैं हमें आप कंपनी ना रजिस्ट्रेशन वगैरह माहिती मिले एलएलपी कंपनी में समझे
Correct.
ये नंबर पे स्क्रीन सेटिंग करेगा
Correct.
और समझे लॉग रिलेशन
Then my lord will turn to the next page.
23/3/2021 ના રોજ રૂપિયા 10 લાખ
Correct.
23/3 ના રોજ
Correct.
10 લાખ અને
I was no way concerned.
25 lakh में आ अकाउंट नंबर this. How much money you have paid to this? How much money he has paid you?
To me,
फरियादी company.
any of the investor nil.
फरियादी आपल्याला
Directly to me, nil.
to the company.
To the company, they claim 54 lakhs something. But one more thing. Before we participate from that.
फरियाद में 25 लाख पे
No, sir. No. And as an officer, I am not.
what is the 25 lakh rupees?
And it, Faryadma, that is saying 64 lakhs 80,000.
64 crore. 64 crore. Not lakh.
64 crores 80 lakhs.
Just have a look at the फरियाद में planning page 4
Yes, ma'am.
second paragraph
I'll read, sir.
दोनों स्टैम्प पेपर एक तारीख 26/3/21 ना रोज
That's
10
it.
लाख
That's it. I will no way concerned, except being an employee.
3/21 ना रोज 10 लाख Service. रुपया 25 लाख में 25 lakh has been paid on these 3 days.
Correct.
RBI company. Why is there फरियाद में 25 lakhs of देना चाहिए? This was the only amount made by this company.
Yes, as far as he is concerned, yes.
25 lakhs
That's
by this company. And what is his name?
he is Mr. It's a company. And the FIR has been lodged by Mr. Prashant Pradeep Bhai Kanabar, foreign on behalf of the company.
What is the investment made by you? Fariadi sir, commission? What is the investment? 25 lakh investment.
નથી દેખો લાસ્ટ ડેટમાં આપણે પેલા જે એમને ભાઈઓ ડિક્લેર કર્યું
फरियाद ना हिसाब
ફરિયાદના હિસાબે તો સાહેબ ટોટલ 64 CR.
read paragraph 4. Page 4.
Page 4.
Page 4. તે પછી અમે આ કંપનીના રજીસ્ટ્રેશન વગેરે
નીચે નીચે પેજ નંબર લખ્યા છે એની અંદર
How?
Yeah.
On the top, you will find the running page.
ચાલુ કરશે તો અમારા બિગિનિંગ જ છે ચાલુ કરશે બિગિનિંગ રોકાણ કરવાની ઓફર હશે ધીસ ઇઝ ઓનલી ઓફર
તારીખો આપેલી છે.
આ બીજા ખેડૂતની
આ ફરિયાદી કોણ છે?
એનો આગલો પેરેગ્રાફ
આ ફરિયાદ કોણ છે? સ્ટાર્ટિંગ જુઓ ને, ફરિયાદી કોણ?
ફરિયાદી પ્રશાંત ચાલક અમે આ કંપની માહિતી મેળવી કંપની સંબંધ અમે આઈટી
Prashant Pradipbhai Kanabar. And that is for and on behalf of the company.
આ તો બીજી
That
જગ્યાની
is the
ફરિયાદ તો
company
નથી.
known as Dhan Bhakti Venture Private.
બીજા આ ફરિયાદ બીજા કેટલી
Amreli.
અમરેલી.
આ બીજા અમરેલીનો
Amreli.
25 lakhs doesn't appear at all.
અમરેલીમાં 25 લાખ.
આ કયા નથી? અમરેલી.
Amreli.
અમરેલી સાહેબ આપને હમણાં અમરેલી.
At the moment, we are on Rajkot. And therefore, I said, please look at the chart. Running page 4. Four and 5
તમને બધા FIR.
of the FIR. The statement appears, the clause 12 appears, starts on page 4.
Ah.
And then the relevant part is, first is the introduction. And then my lord will find another part of it, where it has been mentioned, સને જૂન જુલાઈ 2021. My lord,
તમે જૂન જુલાઈ 21.
that's it. ના વર્ષમાં હું હિંમતનગર અમારી કંપનીના કામથી ગયેલો છું ત્યારે ત્યાં ચંદ્રકાંતભાઈ પટેલ મોબાઈલ નંબર 300 નામના માણસ મળેલા તેમની સાથે મારી પરિચય થતા તેઓએ મને વાત કરી કે તેઓની ચંદ્રકાંતભાઈ પાસે હળદરની ખેતીનું પ્રોજેક્ટ છે. આ પ્રોજેક્ટ મુંબઈની AS એગ્રી એન્ડ એક્વા LLP સાથે 5 એકર જમીનમાં શરૂ કરેલો છે. આ LLP જમીનમાં પોલી હાઉસ ઊભું કરી તેમાં હળદર ઉગાડી વેચવાનું કામ કરે છે. આપણે ફક્ત વીજળી તથા પાણી પૂરું પાડવાનું અને જે રકમ આપણે રોકાણ કરેલ હોય તે રોકાણના 1 વર્ષ બાદ પ્રથમ વખતે રોકેલી રકમ વીજળી રકમ 62 6 વર્ષ સુધી પરત આપે છે અને હળદરના ફાર્મિંગની માણસો વગેરે જવાબદારી LLP પોતે સંભાળે છે. તે વાત કરતા હું ચંદ્રકાંતભાઈ પટેલનું પ્રોજેક્ટ જોવા ગયેલ અને મને તે પ્રોજેક્ટ સારું લાગતા ચંદ્રકાંતભાઈ પટેલ મને AS એગ્રી એન્ડ એક્વા LLP ના પાર્ટનર હિરેન પટેલ મોબાઈલ નંબર 600 આપતા લાગતા ચંદ્રકાંત આપેલ હતા. બાદ મેં રાજકોટ આવીને મારી કંપનીના ડિરેક્ટર સાથે પ્રોજેક્ટ બાબતે વાત કરેલી જેથી તેઓ જણાવેલો કે જો પ્રોફિટ સારું થાય તો રોકાણ કરવામાં કોઈ પ્રોબ્લેમ નથી. તેમ કહેતા અમે આ હિરેન પટેલ પોર્ટ ઉપર પ્રોજેક્ટ બાબતે વાત કરતા તેઓએ અમને તેમની LLP ના મેનેજર સાક્ષી પલવ મોબાઈલ નંબર 300 તથા અવિનાશ સાંગલે મોબાઈલ નંબર 300 ના નંબર આપેલા અને તે લોકો 2-3 દિવસમાં રાજકોટ મોકલું છું ત્યાં આવી તમને પ્રોજેક્ટ સમજાવી દેશે તેમ વાત થયેલી છે. That's the end of the
Who told? Hiren Patel told
Hiren Patel said
that these people will come
these
down.
people, you contact these people will come and explain it. That's the end of the matter.
Rajkot મોકલું છું.
That's it.
He will send them to Rajkot.
That's it. That's the only role attributed to.
No, you are the partner at that time.
No, that is what they allege.
Why did you say?
My lord, a person may lie,
No,
but
you
the
said-
documents will not lie.
No, you said in the complaint, we only says.
And therefore I say, on face of it, whether the complaint can be taken as it is, because it goes without saying that a person may lie, but the document will not lie. And if the documents which have come on record, my lord will find the deed of partnership which has come on record. My lord, that partnership deed says that on 28th August 2021, I became the partner holding 2.5% profit. And leave aside that, my lord, there is an observation of the civil court at Bombay to that effect, admitting my claim that I have been admitted only on that day as a partner. Now, any observation made by a civil court on facts of the case, my lord, unless it is set aside, that remains. And that is what exactly the civil court has said. May I show the order of the civil court?
No, it's too bad. Evaluate.
Now, another two aspects, maybe for our academic interest. I don't know whether that point has been ever argued before this honorable court or not. My lord, we are dealing with a special act. This court is formed as a special court. Now, like this act, there are hundreds of acts which are being made as a special act. All the acts, wherever the legislature or the parliament had an intention that a person being prosecuted under the special act can also be prosecuted under the other act. My lord, that specific enabling provision has been made. I'll just illustrate that. Give me that.
In act in the,
I'm sorry.
in the GPID.
Yes, GPID do not have any enabling provision. Now, first, I'll just show the provisions under the provisions of Prevention of Corruption Act. May I just show? It's the center.
Enabling provision is there, 17(2).
Yes,
17(2).
in the present act, no,
The GPID.
No.
Act, in the
No.
GPID. Act.
no, with all
The
respect.
provisions of criminal procedure code, except 438 thereof.
That's right. That is the- as far as the procedure.
For the purpose of.
Well, that is as far as the procedure.
Ah.
CRPC only contemplates the procedure.
Right.
It doesn't say you can do this or that. It only gives us a procedure. The act provides the enabling provision. May I just give the provisions of all the special acts. Now, first we'll go to Prevention of Corruption Act.
Section.
Please have a look at page, section 4(3). Then my lord, may I have a look at the,
Just one.
I'm only showing the enabling provision.
Section.
Section 4(f).
Section 4. Taking trial of action date. Notwithstanding anything contrary before you.
My lord, I'm sorry, section 4(3).
Yes.
While trying any case.
Yes.
While trying any case, a special judge may also try any offense other than the offense specified in section 3, with which the accused may be under CRPC Act. So
That-
this
then
is
you
the
have to
kind of
look at-
enabling.
You have to look at 9. Section 9,
I'll
GPID.
I'll read. I'll read.
I think it is there in designated code.
Yes, I'll read that, sir. So I've studied a lot. First, I'll show another. Now, this is a Mocha Act. Please see the enabling provision. And then I'll take my lot to decide.
That is, how much is it? Mogogama, the jeep, which it of my customer,
My lord wants you to look at section 9.
Section 9(2).
9. Nine two contemplates no court other than the designated court shall have jurisdiction to deal with or decide the question which the designated court is empowered to deal with or decide by or under this act. Right? So everything is under this act, not beyond this act. What is beyond the act is the provisions of other act. Initially, the FIR was registered under IPC. Please appreciate. Now, if this act by itself is a complete code and there is no enabling provision in this act whereby a person who is being prosecuted under MPID or
Then
JD,
you'll have to look at 9(3).
I'll read it. I'll read it, sir. That's for our academic interest, we'll do. Any case of proceedings pending before any court or any authority in relation to the monies, properties or assets of the financial establishment covered by an order made under section 4 shall stand transferred to the respective debtors. Now please come to section 4. Please go to section 4. Section 4 contemplates the attachment of the property. Right? Properties belonging to whosoever is the accused of beneficiary to be attached under this act subject to compliance of section 5 by the competent authority, then notification in the official gazette, publication, etc. The whole anxiety is that if the properties are attached by one court, there should not be a conflicting order between two courts in respect of the same property. Now, suppose I go and file a civil suit in another court, ask for an attachment before judgment, or take a decree, attach the same property. It will neither amount to pari passu charge. Once it is attached in toto. And recent judgment says that even the creditors whose claims are already certified by any court of law, including the statutory authorities, will not have any preference over the other investors. They have to stand in the same. And that is the whole anxiety. And therefore, I will be coming before this court, or if required before the High Court, that once this court is seized of this matter, there cannot be any FIR to be tried by any other judge. Whether it is Amreli, Ahmedabad or whatever it may be, it has to come before this court. And this is what exactly 4.3 contemplates. Madam, we got
Enabling section, what you say, has been given in section 9.
no. It is not.
Section 9 says,
Under this act, the wordings are under this act, offences under this act.
right.
So therefore, we have to go to the offences. What are the offences? Please go to section
Section
3.
3.
2 and 3. 2 is the definition and 3 is the offences. Please go to that. First go to 2. 2C may be seen.
Right.
Deposits.
Right.
I'll not enter into controversy. What can be termed as a deposit, what cannot be termed as a deposit.
Right.
It's getting now. Please turn to number 3. Because there are so many exceptions being given. So many things have been carved out, and on the basis of that, even this act will not be applicable in the present case. Fraudulent default by financial establishment. So first in time, I have to be, the prosecution has to satisfy that I fall within the ambit of definition of a financial institution.
And
The
it's
second step will be, there is no bar in taking money. Please appreciate the wording.
that is not the issue.
Only when I committed default, and that too a fraudulent default. Please appreciate. Like in 420, non-payment of the amount doesn't become an offense. But the moment we say that right from day one, I had no intention to pay, and all the representations were made by us only to take somebody in confidence by its entire transaction is taken. So there is a difference between two.
So you are saying that this court cannot try other offences other
Correct.
than section 3
Correct,
together with,
correct. My lord, identical is the act that is.
because there is no enabling.
That's right. Now, identical was the issue in respect of ITN, Information and Technology Act. Now, Information and Technology Act by itself like this is a complete code.
That there was no enabling that.
That's right. And therefore, the Honorable Apex Court, as well as the Honorable High Court, had categorically dealt with that situation that no, once you are prosecuted under RT the question of you being again prosecuted under the provisions of IPC, that situation will not arise.
Give me the-
I'll just.
Now, can that be argued at this time? You can make an.
No, I'm trying to suggest. Well, two criteria.
Because
Initially,
I will need a separate application for some other, because
my lord, I'm on a different issue. I'm arguing against myself. For the reason that at one point of time, we used to argue that investigation is over, my custody is not required. And that was the basic arguments coming from this side. Later on, the Supreme Court clarified that no, this cannot be an argument. Coupled with the fact, you have to see what kind of offense has been committed and ultimately what will be the fate of it. This is a rider put by the
I
Supreme
think
Court.
one issue is.
So now two criteria.
One issue is already pending before the Honorable High Court, saying that can an magistrate add section 3? of the
Leaving aside,
This issue is already there.
I know, I'm aware of it.
So the same argument will fall there also.
No.
What?
Yes.
Enabling section.
It depends on the person who represents. How he puts the case. Because unless there is the enabling provision, the question of both the acts being applied together,
It is a question.
I'll just give. Maybe in my car, I'll just give me few
No, you give me
minutes.
the citation.
Give me few minutes. And that is the judgment of the full bench of our Aurangabad High Court. Initially, there was a judgment of Bombay High Court, which traveled to the Apex Court. The Apex Court has stayed the matter, stayed the order, but till date, final orders have not been passed. Again, the same issue had arisen before the Honorable Aurangabad bench. And Honorable Aurangabad bench has considered it in detail and passed that out. I'll just say that within few minutes, maybe lying in my car. That issue settled by the division bench now, unless upset by the higher court, it remains in future. Now, this is one of the points. The second point, my lord, in the present cases, even if I am required to be prosecuted under either of the act or under both the acts, let's go to the worst situation. Initial offences are committed under ITC. ITC and CRPC will go together. BNS and BNSS Act will go together. There is no retrospective effect being given to the new act which has been introduced. If the FIR is registered under the provisions of ITC, then the procedure under the provisions of CRPC will be binding upon the police owner. I am on the point of section 50. Section 50 of CRPC. Time and again, I don't know whether my lord has experienced or not. The police authorities simply lift the person, take them, and then they at the police station at ease. They comply with the permit. Now, this is what exactly the Bombay High Court has been pleased to look into. Whether the arrest by itself is legal or illegal, unless the provisions of section 50 are complied. Dicto case. MPID, here GPID. Please turn to para 3. Just to show what was the issue before the bill. In the wake of registration of FIR number so and so invoking section 406, 420, read with 34 of IPC, in short, to which subsequently section 409 also came to be added, along with section 3 and 4 of MPID Act, for short MPID Act, the petitioner came to be arrested and was produced before the session court on so and so day. When he was remanded to police custody till so and so day, which was further extended till 14/3/2024, and he was then remanded to judicial custody. Identical case. On completion of investigation, the charge sheet was filed. My lord, what? Identical case, barring the last 2 lines. I don't know whether charge sheet is filed or not, but I am told that charge sheet is not yet filed. Para 4. We need not go into the accusation leveled against the petitioner on its merits, as the petition filed its position on the claim that his arrest is illegal, is in the gross violation of the rights conferred on him under the Constitution of India, rendering the subsequent remand orders as null and void, as there is an abject failure to comply with the provisions of section 50 of CRPC. In the petitioner therefore seeks declaration of arrest as illegal, and we would focus upon this very issue and refrain ourselves from entering into the merits of the accusation crystallized into the charge sheet against the petition. Now please turn to para 23. After referring to various judgments. My lords have got para 23. It's on running page 20. On factually examining whether the grounds of arrest were actually conveyed to the appellant, who was arrested on so and so day, the day on which the decision in Pankaj Bansal was delivered, it was noted that the arrest memo nowhere conveyed the grounds on which the accused was being arrested, but it was a simple pro forma indicating the formal reasons for his arrest. Recording the significant difference in the phrase reasons for arrest and grounds of arrest, it is concluded that reasons would commonly apply to the person arrested on charge of a crime, where grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitate the arrest of the accused, and the grounds of arrest informed in writing must convey to the arrested accused all basic facts for which he was being arrested, so as to provide him an opportunity of defending himself against the custodial remand and for seeking bail. My lord, your word. May I read further? Now, in the present case, even the arrest memo is not being given.
charge sheet has been filed. Charge sheet filed. Nah, charge sheet चालू है. No, arrest memo क्या है? Is it saying the conviction? अब पूरा conviction था.
Yes. I have taken full instructions. I will not argue even a single word.
No, इतनी बड़ी mistake तो ना कर.
क्या?
Arrest memo नहीं किया.
I put.
अरेस्ट मेमो आएको चाहिँ लाइभ आएको बोलाइ लियो तर रेकर्ड गराइछ.
Kalyan asking.
And not only the arrest
Yeah,
memo, it should be a reasoning as a observed by the honorable.
Disney का.
Now please go little further. By concluding that grounds of arrest would invariably be personal to the accused and cannot be acquitted with the reason of arrest, which are general in nature, the apex court held that the appellant was entitled for his release by applying the ratio laid down in the Pankaj Bansal case. By recording that the arrest of the applicant followed by the remand and also the interim order passed by the High Court of Delhi were invalid in the eyes of law, the same was placed in set aside. The decisions of the apex court in the case of so-and-so, which now is a law declared by the apex court in the wake of Article 141 of Constitution of India, bind all the courts within the territory of India. Similarly, in terms of Article 144, since all the authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court, the law shall be followed by all concerned, including the courts as well as the authorities exercising the powers of arrest. In the light of elucidation of law in the above manner, the focus in clause number 1 of Article 22 of Constitution of India, when we have examined the present case, it is evident that the ground of arrest were not furnished to the petitioner in writing, and the arrest surrender form Panchnama produced before us column 8 is unfilled column, which is fact expected the arresting authority to ensure whether the arrested person, after being informed of the grounds of arrest and his legal rights, was duly taken into custody on the date, hours, place. The form only indicates that the intimation of arrest was given to Lakshmi Panduran Naik, mother of the petitioner. The station has the entry record that a note of arrest has been taken in the concerned register and he was apprised of the reasons of arrest, and thereafter he was arrested. The procedure followed by the respondent number 2 is evidently in violation of subclause 1 of Article 22 of Constitution of India. And since these provisions now stands interpreted by the apex court and in the wake of declaration coming into effect from 3rd day of October 2023, any arrest made thereafter must ensure compliance by indicating the grounds of arrest in writing expeditiously. The ratio laid down by the apex court having been declared to be a law of the land, binding on all courts of the country by virtue of Article 141 of Constitution of India, needless to be stated, must be followed by each and everyone, including any officer, person, magistrate, before effecting arrest of a person in any case where his arrest is deemed necessary. And this ground shall contain all such details in hand of the investigating officer which necessitate the arrest of the accused. My lord, sir, what? And then please turn to the concluding part of it. On the same page, resultantly, the remand order dated so and the subsequent orders passed by the special judge, MPID, Court, Greater Bombay also cannot be sustained and are liable to be set aside, and accordingly they are set aside. Upon setting aside of the aforesaid order, the petitioner is entitled for his release, and since the charge sheet has been filed against him, we direct his release from custody on furnishing bail. Then please turn to para 27. To be circulated to all the departments for due compliance in future.
Here also they must be following the procedure and call for the papers.
Merely giving a memo of arrest in a printed format doesn't help. The law of the land says, no, you have to give whatever investigation you have made, which has necessitated your arrest in the matter. And that is absent. And then if either we go by way of IPC, or if we go by way of IPC, then please look at the sections applied. And if we go by GPID, if the sections applied are taken into consideration, My lord, at the highest, under GPID, the punishment can be 6 years.
That is already, I told my. This is very.
And therefore,
For 20
the
years,
judgments
it
which
is-
have come, that will come. Including the judgment in the case of Delhi race. And that judgment, I'll just take a printout, I'll get it from my card.
You give me that IT,
ITA, yes,
that is more than.
that is of our Aurangabad bench. Just give me 5 to 10 minutes.
आपने